Come along with us as we explore the broad world of preservation and the work being done to preserve, interpret, and save our past in a 21st century world. From aquaculture to historic foodways to forensic modeling, we're talking weekly with experts from across the globe. This is your host, Nick Redding. Welcome to PreserveCast. This is Nick Redding, and you're listening to PreserveCast. Excited today to be sitting down with two colleagues who have done a lot of work in the heritage and preservation legal field, which is a subject we've touched on every once in a while here at PreserveCast. But we've had some listeners reach out to us and ask us about how everything that's happening right now in the news is impacting historic preservation. And we thought it was important to answer some of those questions and to bring on people from the field who are working on these issues right now. And so we're going to be talking with both Marion Werkheiser, who's the founder of Cultural Heritage Partners, an attorney with this organization, and Will Cook, who is a partner and attorney with Cultural Heritage Partners. Before we kind of jump into the meat of it, we like to get to know people. We also like to get to know sort of the broader, sort of trends of their field and where they work. So we'll talk about Cultural Heritage Partners here in a second. But before we get there, why don't we start with Marion, and then we'll jump over to Will. Marion, where'd you grow up, and how did you get into this line of work in particular?
I grew up in Memphis, Tennessee. I've always been a political junkie, and I had a passion for history. And so when I got to college, I decided to double major in political science and classical archaeology. And at some point, I figured I would have to choose which path to go down professionally. And my wonderful professors at Indiana University, shout out to Katie Vitelli and Kevin Glowacki, they encouraged me to think about how I could weave those two interests together. With their help, I realized that the problems that I want to solve in the world have to do with answering questions about who gets to own the past, who gets to interpret it, and how those stories and artifacts are shared with the public. So I decided to go to law school to become a cultural heritage lawyer and to build out this field of practice.
That is a very sort of unique origin story that we get. Sometimes things are much more circuitous, and I'm sure there was some twists and turns in there. I am curious, just because you said where you grew up and what kind of got you interested. We ask a lot of people, and oftentimes there's sort of like this inspiration point, or there's a moment of sort of spark of interest. Was it because of parents that took you places? Was it something you saw? What was that inspiration of the past?
I had a grandmother who loved to travel, and she would take me lots of interesting places. And it always surprised me. We would go to these museums or these churches that I had read about and thought so highly of. And we would get there and realize that the security wasn't great. Some of these places weren't very well taken care of, and they were so important to our story. How could we do a better job of preserving these places and making sure that they would be around for future generations? So a lot of travel, I think, and seeing how other places deal with preservation got me very excited to do it here.
Yeah, that's cool. That's it's a common thread. I would keep saying that we're going to do something where we kind of pull out these data points, and oftentimes it's some type of trusted adult takes people at a young age to a place, and that's all that it takes. So so Will, a little bit different story for you, but let's hear about where you grew up and how you got into all this.
Sure. I have a little more of a circuitous route. I'm a little bit older than Marion, and the preservation law field wasn't quite as evolved as it is now. But I grew up in a little historic town called Beaufort, South Carolina, which I like to say, even though it's a small town, has one of the largest National Historic Landmark districts in the country. And Beaufort's situated between Charleston, South Carolina, and Savannah, Georgia. So I lived in a place that very much had a strong preservation ethic, just kind of permeated, the local ethos. My father was a U.S. history professor, had a deep love for history, was an early member of the Historic Beaufort Foundation. Like Marion, I too had an interest in political science, ended up going to law school. At that time, there was not really a direct path. It came out in 1996. There wasn't a direct path into historic preservation law, but I will credit the executive director of Historic Beaufort Foundation at that time, the local historic preservation advocacy group, Cynthia Jenkins, with letting me know that there could be this opportunity down the road in historic preservation law. I thought, well, that's interesting. And so I kind of tucked that in the back of my mind. I took a more traditional, law school path, appellate clerkship path, became a law professor after some years practicing at a large civil litigation firm as a property law professor and a constitutional law professor. After joining the board of the Preservation Society of Charleston, which is one of the oldest membership-based advocacy groups in the country, I started teaching one of the three, I think, elective courses that are taught in law school in historic preservation law, which was a source of, gave me a lot of pleasure to expose law students to this new area that I wasn't able to study because there wasn't this area of practice then. When I was in law school, I first became, I would say, directly involved in historic preservation advocacy, maybe inadvertently, while I was on the board of the Preservation Society of Charleston and teaching full-time at the Charleston School of Law. The big preservation controversy came about in Charleston involving the building of a large cruise ship terminal at the edge of the historic district. And Bland Holman, a lawyer at the Southern Environmental Law Center, and I teamed up. We represented a number of local preservation advocacy groups and some historic neighborhood associations, and going to federal court against the Army Corps because of some failures in the Army Corps' application of the National Historic Preservation Act and the National Environmental Policy Act. And we were successful in that litigation. That was my intro into like formal, I'd say, preservation advocacy, and then joined I took a sabbatical from law teaching for a couple of years to join the law division of the National Trust for Historic Preservation in Washington, D.C., where I focus, 100% of the time on applying federal, state, and local historic preservation law for the National Trust in support of its partners and allies all over the country.
Yeah, no, and we've known you at different points throughout this, and I've followed you at different points throughout this. I think I was following along with what was happening in Charleston before I even knew you, and I kind of, people can't see my face and in this audio podcast, but I sort of snickered when you said that was like your intro to preservation. It's like, just this seminal moment in historic preservation law in the last 20 years was sort of your little, coming out with law on this issue. So what an important bunch of different things that you've worked on. Really cool and important work, and couldn't have two better people here to talk with us about this. So Marion, in a nutshell, I think probably there are some listeners who are hearing all of this and are like, wow, I didn't even know preservation law was a thing. Not only is preservation law a thing, there's a firm dedicated to heritage law. Presumably, maybe there's others too, but I know of one, and that's Cultural Heritage Partners. In a nutshell, just for people listening who are curious before we get to the meat of the interview, what is Cultural Heritage Partners? What kind of law do you work on? I mean, obviously, we're hearing things about cruise ship terminals and road expansions and all sorts of things, but how do you define the work of CHP, which you helped found?
Yeah, our firm is going to be 15 years old next month. Very exciting. We're a private law firm, but we have a public mission. We want to leverage humanity's past to create a better future. And we take on matters that advance the principle of cultural heritage as a human right. We're different from your typical law firm in that our team, of course, includes attorneys, but we also have historians, tribal specialists, archaeologists, and art scholars who work with us. And we serve our clients globally. Will and I focused our practice on what we call high impact Section 106 matters. Um, these are situations where a proposed development, like a cruise terminal project, is going to impact places that are important to tribes or local governments or descendant communities. So we will come in and advocate for location or design changes to try to avoid and minimize impacts. Um, and when agencies permit projects that are going to have unavoidable impacts, we will often be able to negotiate for meaningful mitigation for the communities that value those resources. So we've become particularly experienced in negotiating creative mitigation agreements that put tribes, local governments, and stewards of historic places in the driver's seat to interpret their own history and direct their own funds to advance self-determination. So we're pretty proud of that, and being able to help balance development needs with preservation values, which is the cornerstone of the National Historic Preservation Act. I should also mention.
Oh,
yeah,
go
go
ahead. Well, I was just going to say I'm always taken by the diversity of the work, just the number of different topics you can touch through heritage, and the diversity of the work that CHP does. And this is not an ad for CHP, so but it sounds like it. But I've always been impressed by it, and I think it's kind of cool and interesting to bring you on at this moment so people can hear from you, because we've done different episodes over the years. We did one on 106 at one point in the past, where what this law what this law says and what the regulation means, and this is kind of where the rubber hits the road oftentimes in the courts if there can't be resolution in the meaningful mitigation and consultation process.
That's right. And I'll say our firm certainly has other practice areas. We also do a lot of work with museums and art collectors, do a lot of work with tribes. But we've also taken on initiatives for the preservation field where there's been a leadership gap. So during the first Trump administration, we organized the Coalition for American Heritage, which brought together a whole bunch of different national organizations to advocate for cultural heritage and funding during that period. We organized Preservation 50, which was the largest ever coalition of preservationists to celebrate the 50th anniversary of the NHPA. And I'm particularly proud that a couple of years ago, we got bipartisan passage in Congress of the African American Burial Grounds Preservation Act. So we also take on these initiatives where we see a need. And a lot of what we're doing right now is trying to educate the community about what is happening in Washington, how it is dramatically changing the way that we do historic preservation, and what people can do to fight back and make sure that our places are protected in this really challenging time.
I think that's a great sort of segue then, and maybe we'll pitch it over to Will. There's a lot of different ways that you could look at what's going on right now. There's funding issues, there's policy issues, there's staffing issues, and obviously in the next 10, 15 minutes, we're probably not going to be able to cover and solve all of them. Although if two people could do it, it's probably Marion and Will. But what I thought we might do is kind of focus in on this Section 106 piece, because I know you guys held a webinar and that's recorded. We'll put a link to that in the show notes. So if people want to really dig in and hear a little bit more further, dig into some of those resources, we can link people up to the CHP website for some of that. So this is we're bringing a law professor in, but we're asking them to do the 101 or maybe even the remedial course before we get to 101. But with respect to 106 and sort of the changes afoot and some of the challenges to historic preservation law right now, what are we seeing writ large, and to the law community and to the preservation law community in particular, what is concerning and where are these sort of friction points that we're seeing being set up right now? We're hearing a lot about executive orders, so I thought maybe we could kind of start there. People are hearing about this stuff, and we're hearing about it in different aspects of life and legal fields. Not as many people are hearing about it in preservation, which is why we're bringing the conversation here. So how are these executive orders in particular impacting historic preservation, and how might it impact a historic place?
It's a really good question, Nick. As you know, we've been dealing with, this onslaught of different executive orders, that roll out. I don't think it's an understatement to say that almost every day, purporting to find a new way to effectively eviscerate or invalidate the traditional procedural protections afforded by Section 106 of the National Historic Preservation Act, Section 110F of the National Historic Preservation Act, which applies to National Historic Landmarks as opposed to properties listed in the National Register of Historic Places. And then also, our work interfaces unavoidably with NEPA, or the National Environmental Policy Act, to the extent that it addresses or requires federal agencies to consider environmental harm that might arise from federal projects. And this also includes harm to historic and cultural resources. Just to maybe drill down a little bit about what's causing this wholesale attack on our federal preservation laws. This really started on January 20th of 2025, when the president signed a declaration that declared a purported national energy emergency. And, there are a number of, there are myriad national environmental groups: Sierra Club, Center for Environmental Integrity, Natural Resources Defense Council, Center for Biodiversity, Earth Justice, you name it. The list goes on, that are working very hard along with us to find ways to attack these various executive orders because of the way they undermine our environmental laws, including those that address historic properties and cultural resources. But in short, these emergency orders are fast-tracking a wide array of federal projects, including oil and gas pipelines, coal mines, processing plants, electrical transmission lines, nuclear facilities, roads and bridges, anything that may facilitate the development or transmission of energy. I mean, this is just one executive order, for example, one of the early ones. Not included in this are solar and wind power energy developments, which I think is just an interesting thing to note. What's happening because of these executive orders are, I guess, two things that are designed to vastly speed up the approval process for energy and energy-related projects. The use of eminent domain that would allow the government to seize private property for energy development, but also this overall skirting of the protection provided by environmental and historic preservation laws, including, the Clean Water Act, the Endangered Species Act, and of course the National Historic Preservation Act, and NEPA. The way that this gutting of these federal laws is happening is that the executive order and orders are directing federal agencies to apply what are called emergency provisions, usually reserved for times of natural disaster like hurricanes and wildfires and floods. That are, these emergency provisions are built into the Section 106 process so that there can, be faster response time to deal with, natural disasters and things of that nature. There's never been a situation where there's been a, energy emergency, which, we know that we're not in an energy emergency just as point of fact. But the way that these executive orders are working is that, at least in the Section 106 context, agencies now have only two things they have to do under these emergency provisions. First, notify only the Advisory Council on Historic Preservation and any applicable state historic preservation officer and tribal historic preservation officer or affected tribes or Native Hawaiian organizations that there's a federal undertaking that's up for permit review. And there's a 7-day comment period. And after that 7-day comment period ends, that permit can then issue. There's not even any requirement that the federal agencies have to consider any comments that are received. So there's now, just a 7-day process. Comments can be registered or not if Advisory Council or SHPOs even have the ability, or tribal historic preservation officers even have that ability to lodge an objection in 7 days, which is highly unlikely. And so what's missing is that there's no longer a requirement, like under traditional Section 106 and the regulations, that there's a formal assessment of adverse effects. There's no more requirement to engage the consultant, the public, or to notify potential consulting parties who have legal or economic interests in these undertakings. And also no requirement to resolve adverse effects. And so, which means that Section 106's emergency provisions don't require any avoidance, minimization, or mitigation. And piling onto this, other executive orders are now or have proposed changes that are now underway to other statutes like NEPA, where we're now facing 28-day periods to issue environmental impact statements, as opposed to 2 years, which in some situations is fairly expedited. And when environmental assessments are required, only 14 days. And so I think it's fair to say, this is not due process. This type of process probably result in arbitrary and capricious decision-making, which is the legal basis for setting these types of approvals aside, which will create lots of uncertainty for project applicants. And will have the ultimate effect of like serving an eviction notice on our country's history.
So that's a fantastic answer, very succinct. And, I think totally understandable. I was even able to follow it. And so Will is a great law professor, because he took a very complicated subject and made it pretty plain spoken and easy to understand. Marion, I want to ask you, for someone listening who just digested that, who maybe this is the first time that they're even really thinking about preservation law, or like that this is an issue for something in their community. Maybe they come to this podcast as like, hey, I love historic places and I love learning how people save them, right? Can you tell me, can you give me a good example? And we haven't prepped you for this or anything, but could you give me a good example of where Section 106 has been used to save a place, and how this change in the process could potentially have upset a good outcome? So a place that people love, or someone loves, and then 106 came together, had the desired outcome. The project still moved forward, but it resolved some of those issues. But a situation where that would not have probably happened under this current setup.
Sure. I've got a great one. It was a case that our firm took on a couple years ago in Virginia, where there was a proposed water pumping station that would allow for development of data centers. It was planned on top of the historic capital of the Monacan Indian Nation. It's a place called Rassawek. Rassawek is at the confluence of the Rivanna and the James Rivers. And it was documented back in the 1600s by John Smith. It's on the first map of Virginia. We've known where it was forever. The water authority applied for permits to build this pump station, which would have disturbed the burials of Monacan ancestors and disturbed one of the most significant places in colonial history. And they, because of Section 106, they needed a permit from the Army Corps of Engineers. And so consultation began with the tribe. And the tribe said, hey, wait, this is our most important place. This was our historic capital, the town to which all the other Monacan towns paid tribute. You can't dig up our ancestors and destroy the site. You would never do that to Jamestown, which is a contemporary place. Their objections caused the Army Corps to slow down, to require more documentation about the project, to do more advanced reconnaissance and survey to understand the site. And in the meantime, we were able to organize a group of over 12,000 individuals and organizations who filed comments on the record objecting to this project, saying it's not worth it to destroy this site. And as a result of all of that public involvement and negotiations with the Army Corps and with the developer, ultimately the developer decided to move that project 2 miles away from Rouseawek. They still get their water supply project. Those data centers are still in the planning stages. And that site that is so important to American history is now going to be preserved. If we had been given 7 days notice before they approved that project and started building, there would have been no opportunity for any of that discussion, for any deliberate decision making, or even for the developer to consider other locations where they could build that project.
I think that's a really, really helpful. I remember sort of following that work. I've been a CHP, I guess, groupie for a while, so I'm familiar with some of the stuff that you're talking about here. But I think that's really helpful. And we have 2 attorneys here, so I'll let either object if I get this wrong. But the roots of all of this is in the urban renewal of the 1940s, 50s, 60s, where the federal government would go in and really just wholesale disrupt, destroy, harm communities. And in some ways, this is a response to that, in that this is a law that says communities should have a voice when the federal government is in their backyard in particular. And so in, sort of respecting federalism and local community control, this is a tool for that. This is not a delay or unnecessary burdensome regulation. This is so that people can kind of control the future and the way that their communities will grow. Is that sort of a fair assessment of this? And perhaps something people should be thinking about when we're talking about regulations, and how this is actually a hedge against sort of, the federal government coming in and just saying that this is what's going to happen in your backyard. You're going to get an interstate. You're going to get a pumping station, whatever that might be. Is that sort of to kind of give people a sense for where all this stems from?
Absolutely.
Yeah, and I love your sort of setup for this question, because everything that you're describing is what led to the creation by Congress in 1966 of the National Historic Preservation Act, and shortly after that, NEPA, and Section 4F of the Department of Transportation Act. The 60s were in a time of intense, major infrastructure development all over the country. This is the era of Robert Moses, like you said, bulldozing communities to build new highways, new freeways, throughways, bridges, you name it. And there was certainly a recognition that towns and cities, because of these infrastructure projects, were losing vast swaths of their historic fabric and identity. And that culminated in political action that led to the passage of the National Historic Preservation Act, among other federal preservation laws. But the idea was that the infrastructure development prior to 1966 was happening so fast, there was no public information about it, that communities didn't have an opportunity to react and to use political pressure to try to create different outcomes. And so what Section 106 and NEPA did, they were designed to be information gathering statutes to alert the public about the effects of these massive federal projects or undertakings, so that the public would not just understand what the environmental consequences could be, including harm to historic and cultural resources, but also would have this formal set of procedural protections, like Marion was describing, that would allow communities to have a role in at least understanding what historic properties were affected. And then to the extent that they were going to be harmed, there would be this opportunity, not a veto, but an opportunity for parties with preservation interests, advocacy interests, legal or economic interests, to have this chance to work with federal agencies and permit applicants to find ways to avoid or minimize or mitigate harm. And so that's the foundation for these laws. And we often, unfortunately, get involved when the Section 106 or NEPA process has become broken. But I know Betsy Merritt speaks very passionately about this. There's so many examples of where Section 106 and NEPA produce positive outcomes that don't often get reported widely in the public.
And Will, if I could add, I mean, one of the things I'm most worried about with the use of these emergency procedures is we're not even going to know what we're losing. Like when you have, like, for example, the built environment, when you have, portions of cities that are going to be impacted by highways, you can see what that impact's going to be. 90% of the archaeology that's done in the United States is done because of Section 106, because the federal agency has to go look and see what they're going to impact. And without any meaningful review, without any identification of the properties that are going to be affected, we're never going to know what we lost. And we're also not going to have monitors out there on the sites to let us know when sites are actually being hit. So I'm very concerned that we're going to lose so much and not even know it.
Yeah, and I think you're right, Will, in that the good stuff doesn't go reported. It's like people don't go on Yelp to talk about how great the hotel was. They only tell you how bad it was. And I can think of examples in our work where we've saved buildings and people would drive by it and would never know, but it was just because an organization and a developer got together, and in the consultative process, they said, "Oh, we didn't know this was important. We'll just kind of move our project, 10 feet over this direction." And I mean, in some cases, it literally was that, and ended up in that direction. So this is almost like we probably could do this as like a part one, and then have you come back for part two, which is what happens next. But let's tease that at the very least and say, okay, we've identified the program, we've identified the law, we've identified what it does and the success of it, why it was created, and the current challenges and threats to it through this expedited process. Maybe kicking it over to Marion, where are we now? Is this playing out in the courts like so many things, or has this not really been challenged yet, or is there not a way to challenge this?
There are ways to challenge it. And we are looking for the right case to bring. And so I would encourage your listeners, please let us know if you are seeing a situation where an agency is fast tracking a permit without a full review. If there are particularly like African American or tribal burial grounds that might be threatened, we need documented sites that are extremely sensitive in order to bring the strongest challenge. And we need to be able to show that we have a plaintiff who has experienced damage. So one of the big challenges of historic preservation cases is figuring out who has standing to sue. So if we can find a tribe or a community that can demonstrate a connection to a place that will experience real harm from that place having been destroyed, that's the kind of situation where we can bring that and try to challenge the underlying executive orders that are putting this into practice. So I've actually set up a Signal account, and I've got email accounts, and anybody who wants to reach out can go to our website and do that. But we're really we need help from the community to find the right set of facts to have the best chance of knocking these orders down.
I think given the complexity of all of this, that's probably maybe a good place to leave the conversation today. And then maybe we come back for, like I said, a part 2, because this could go in a lot of different directions, but I feel like this is a good bite-sized nugget that someone could dig into at any level that they're coming to this from. Whether they're, a preservation law junkie or just preservation law adjacent or curious. There's lots of different ways to come at this. And as I said at the outset, we'll link some of the stuff, some of the great work that you guys have already done, and sort of the more resources. A lot of different people thinking about this from a lot of different perspectives, as we said. I mean, there's a lot of different arguments that can be made, whether you're concerned about an overreaching federal government, or whether you're concerned about states' rights, or whether you're concerned about local review or tribal rights. There's a lot of different ways of looking at this issue. There's no one set way of looking at this. And here at PreserveCast, we like to bring different perspectives to the table so that people can kind of see what's going on and how people save places. And this is saving places in real time right now with 2 people doing some amazing work. We're just lucky to have time with them today. Before we go, we'll end on a lighter note, which is we always ask people what their favorite historic place is. And oftentimes it's a place that's special to them, that they grew up with. And if they have a very hard time picking it, we normally let them squirm out by saying the favorite place they've most recently visited. We'll kick it off with Will.
That is a tough one. I'm a big fan of, so many historic buildings, so it would be really unfair to pick one. I would say my big interest these days involves large-scale landscapes. We've been doing a lot of work in the offshore wind development arena, and I have become more and more steeped in the importance of protecting this historic, historic oceanfront context of, what I'd say purpose-built communities like the town of Nantucket or city of Newport, city of Charleston, and thinking about not just, historic buildings there, but everything you see from the skyline to the seascape. And so I think landscapes right now have captured my attention the most. And whether they're, off the coast of Nantucket or in places that are under constant threat, like the Grand Canyon, I think landscapes have really captured my heart in recent years.
I like that a lot. And in 350 episodes, I don't think we've gotten that answer yet, so that's good. Marion, you're on the hot seat.
I think I'm going to go with the Lorraine Motel in my hometown of Memphis, Tennessee. Obviously, very upsetting history, but when you go there, you feel like you can experience it in real time, and it's a connection to the people who are part of the civil rights movement. We actually just lost last week the Claiborne Temple in Memphis to a fire, which was also a really important site. But I think those places where our history changed for good or for bad, those stories are really important to tell. So we have to double down on preserving the ones we still have.
Yeah, absolutely. That's a fantastic answer. We did a whole episode on saving civil rights sites, so we'll have to connect that to this episode for people who want to dig into that and the history there. I appreciate you guys so much joining us. I know you guys bill by the hour, so I'm trying to get you off within an hour. I'm just kidding. They're not billing us. But I appreciate it. I know that your time is really precious. And again, an open invitation to come back and talk to us and let us know what's going on anytime on any topic. We love to hear from both of you. So passionate and so well-spoken. Thanks so much for joining us today, both Will and Marion. Will Cook and Marion Werkheiser of Cultural Heritage Partners. Thanks again.
Thank you.
Thank you, Nick.
Thanks for listening to PreserveCast. To dig deeper into this episode's story, head over to preservecast.org for show notes and our collection of previous episodes. Don't forget to engage with this podcast by subscribing, commenting, and leaving a review. Follow along on Instagram, Twitter, and Facebook at PreserveCast for even more. PreserveCast is currently recorded in Walkersville, Maryland, and sponsored by the 1772 Foundation, and powered by Preservation Maryland. Thanks for listening, and keep on preserving.